This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 30 years. Find out more at roundtablegroup.com.
Welcome to Engaging Experts. I'm your host, Noah Ballmer, and today I'm excited to welcome Benjamin Mink to the show. Now, Mr. Mink is the CEO of GTC Consulting, a DEA compliance and litigation support firm. Additionally, he's on the board of directors for the Ohio chapter of the National Association of Drug Diversion Investigators, and he is a leading expert in suspicious order monitoring in opioid litigation. Mr. Mink holds a master's in criminal justice from Everest University at Tampa. Mr. Mink, thank you so much for joining me here today on Engaging Experts.
Thank you, Noah. It's a privilege to be here.
Of course, let's jump into it. So you've been an entrepreneur and a compliance professional for well over a decade now. How did you first become involved in expert witnessing?
You know, it's really one of those things that sort of found me. I was working for a pharmaceutical company in near Dayton, Ohio at the time, and they unfortunately had some compliance related issues that were for activities that took place before I ever arrived at the company. This was 2015 timeframe, and ended up an order to show cause was issued by the DEA against the company, which is a pretty severe enforcement action by the DEA. The State Board of Pharmacy was frequently visiting. The United States Congress became involved and started to investigate the company. So it was sort of a trial by fire situation. I had to very quickly immerse myself in understanding DEA compliance and quality and sort of all of those things that go with risk mitigation in the pharmaceutical world. So I sort of experienced my intro to it in a baptism by fire sort of way.
Absolutely. Tell me about that phone call. You know, you get this initial phone call out of the blue, and they're asking you a bunch of questions. How do you vet someone? How do you know whether or not this is something that you're willing to do and that it's even in your wheelhouse?
You know, I've always had a passion for public health and safety. My background is a little bit unique. A lot of guys that do what I do retire from the DEA, and this is sort of a retirement thing for them. In my case, I started out in law enforcement at a city department and attended graduate school full time to obtain my master's. And I advanced my career in law enforcement. I ended up becoming an Alaska State Trooper. Was featured on National Geographic when the show Alaska State Troopers came out. And I went from there back to sort of central Louisiana, where I started my law enforcement career out, and took a position as an undercover narcotics detective working on a federal task force. And sort of my dream was always to become a chief or a sheriff and kind of climb that ladder in the public service community. And I realized really quickly that, one, I was never going to be able to pay for my graduate school, unfortunately, in a public service career. So I began looking at other opportunities where I could still fulfill my passion for public health and safety while combining that with sort of a drug enforcement capacity. And so I naturally fell into the role that I took at Miami Lucan, which was the pharmaceutical distributor I mentioned. And that was sort of kind of how that took place is I'm always willing to help people with situations like that, because a lot of times it's a situation where there's a lot of naivete when it comes to compliance or just not a lot of awareness. And so I kind of feel a burden to do that. So it was a natural fit for me.
Yeah, it's interesting that you mentioned wanting to help people in the public service. As an expert witness, what is important vis-a-vis helping people? In other words, what do expert witnesses do that is good for humanity overall or jurisprudence generally? Why are expert witnesses important?
Yeah, that's a fantastic question. And the reality is, I think that they're critically important because both sides of a case have a story and both have facts. And a lot of times, if you look at one set of facts in a vacuum, you're not really getting the accurate picture of what's really happened in that case. The plaintiff's job is to say, hey, this organization or this individual did all of these things wrong. And then it's the defense's opportunity to come back and say, well, we didn't do all these things wrong. And perhaps, there were some things that were done wrong in the process, or some of what the plaintiff says is factually accurate. And so it's really important from a fairness perspective, even just from a societal standpoint, in ensuring that cases have a relatively fair outcome, that both sides of the story are told to the jury so that they can get a truly accurate picture as to what happened. And so I really take a lot of pleasure in being able to do that. And that's where I think, a good expert isn't necessarily an encyclopedia. It's a good translator, somebody that can break it down to a jury to the point that it's easy to understand what happened or what was supposed to happen.
As an expert, you're often inundated with all kinds of technical speak and legal speak. When it comes time to translating some of this for the fact finder, be it a jury or a judge, or even write it in an expert witness report, how do you break these potentially complex topics down so that they are more understandable?
Yeah, also a great question. The reality is that I've done this for a while now, and so it gets easier, almost like secondhand, for me to be able to do it at this juncture. Now, starting out, that wasn't the case. I realized really early on that I was doing a great job of retaining and explaining the information at a high level in a technical way, but it wasn't really as beneficial as it should have been, because I didn't understand at that time that my job was to be a translator. I thought I was just there to kind of be the knowledge guy, like, hey, this is what's supposed to happen, and this is how that plays out. But being able to break that down for anyone to be able to understand is really, really critically important. And so I try to put myself in the shoes of a jury member. And I say, you know what, if I was on the jury, how would this make sense to me? What's the easiest way to explain this so that I could understand it if I didn't have the technical knowledge that I do have? And so I think that's a really important thing, is being able to just understand that if you speak in the technical language to someone that doesn't understand, they're not going to understand it.
So you bring up jury trials. How do you get ready for it? So I've had expert witnesses say, I like to cram everything the morning of and make sure that it's fresh in my head, or I drink a ton of coffee and do yoga, or I fast. Do you have any pre-trial rituals or preparation techniques?
Yeah, I definitely don't fast. I feel like I'd get low blood sugar, because sometimes those those run a little long, and I feel like the worst thing that could happen is have your expert faint midway through a deposition. So that's definitely not something that I would do. But I will say one of the greatest prep tools that I have used, and something that's really benefited me as an expert, is I try to really pay attention to past depositions. And so even the fact witness depots, because if you really read those carefully, you'll find certain places that the opposing counsel really focused on. And so I spend a fair amount of time when I prep expecting those focus areas to likely be the focus areas that take place in my deposition. And so that sort of helps me, because like you said, we're dealing with such a large quantity of information. I mean, thousands and thousands of documents, and then hours and hours of just preparation and report writing, all of these things. And so I would love to be able to recram it all in my brain the morning of, but I don't know that I have the capacity for that. So I try to just focus into thinking where would the opposing counsel, where's most likely for them to go in terms of their questioning, where are they going to head with this? And that's where I spend the most time preparing.
You mentioned, thousands of pages of documents and tons of preparation. Do you feel that attorneys could do a better job winnowing the wheat from the chaff when they are giving you the initial documentation for the case? Or do you feel like it's important to have all of those documents at the ready? And when you are inundated with all of it, does that mean that you should be reading every single page of everything that comes over your desk?
Yeah, I mean the challenge is time, right? I mean, we a lot of times you only have so much time before the report is due, so much time before the deposition is due. And so you know, you would love to be able to say I can look at and retain every piece of information that they give me. And so there's a sort of a two-sided coin. One, it's really great if counsel gives you anything and everything because, you may see something that otherwise they might have thought wasn't important that you picked up on that could be critically important as the expert. And so by limiting the amount of information they give you, they sort of do themselves a little bit of a disservice. But at the same time, they have to be careful not to inundate you so much with so much useless information that you can't find what's critically important in the data. And so I think it is a balance, and different law firms have approached this differently. I've worked with several, both big and small. Some give you information in pieces and chunks, and that works. Sometimes it's nice because you're not overwhelmed, and they have some key things they want you to look at early on, which I think is a really smart way to do it. And then they continue to sort of feed you new information as that goes. But again, that all depends on the amount of time you have, because there are instances where they've had an expert that couldn't deliver or something went sideways and they have a very short runway. And so there may not be much of a choice but to give you a very large quantity of files in a short amount of time.
Does whether or not you have what you perceive to be sufficient time factor into whether or not you decide to accept an engagement?
That is an excellent question, and honestly, one I'm kind of glad you asked. So I have turned down cases because there just was not enough time. I'm not going to risk a Daubert claim or something like that because I'm insufficiently prepared for something, and I'm not going to deliver something that's half done. As an expert, your reputation is critically important. I mean, critically important. It can make or break your career as an expert. And so, as much as I would love to be able to say to every law firm that comes to me, yeah, we can take that case, there's just certain instances where I say, hey, that's not enough time. We can't do that. We can't take that sort of risk. And we wouldn't risk doing your client the disservice by taking that. And I understand there are rare circumstances where things happen that are outside of their control. But there's also times where I feel like, maybe counsel was trying to save some money and this was a last minute effort. And that's just, an unfortunate situation. It's one of those things that we wouldn't be the right firm because we won't take that sort of risk.
Have you been subject to a Dobert challenge?
No, I have not. And I think that's a testament to the fact that uh, myself and the people on my team, we really spend the time preparing, and we make sure that every T is crossed and every I is dotted. Nothing we do is fast or loose or corner cutting. And really, I mean, that's how we do everything in our firm, because compliance is such a critical focus point. I mean, we are, at the end of the day, we are risk managers. So if we aren't exceptional at managing the risk, then we shouldn't be here.
Once you've accepted an engagement, what are the factors? How do you make sure, and how does the attorney ensure that it's going to be continuously a effective, efficient, and productive engagement? How do you get off on the right foot, and how do you maintain that momentum?
Yeah, so I think that mutual trust is extremely important. And I think that begins after the initial introductory call. Is I think counsel has to have a certain level of confidence that this individual is going to deliver. They're going to be reliable. They're going to show up. They're going to be strategic. They're going to bring great insight and help us with this case. I think that first impression is really, really important. And that can't be understated. And then I think, in terms of counsel has to give a certain level of trust in order for that relationship to be mutually beneficial. And it's funny because you would think that maybe a lot of firms handle that the same way. It is very, very different. I've had firms that are like, hey, take off and do your thing, and we'll check back in a month. And I'm like, that's awesome. I mean, I love that level of trust. Then you've had others that maybe have been burned or had a bad experience, that they sort of micromanage the process and they want to have a weekly call or maybe even more frequently than that. And, the reality is we accommodate either way because we want the client to feel comfortable with the situation. And usually, even with the ones that have a more watchful eye on the progress, that trust develops. For some people, it just takes a little bit longer. And so don't be surprised if you're new to this and you have a sort of a micromanagement experience, because there is a lot of pressure. There's a lot of pressure on the law firms, on the counselors there and with the client. And so I try to be understanding of that. I understand there's a lot that has to be accomplished and a lot riding. It's a very high stakes situation.
Absolutely. Are there any red flags that you look out for, things that during those initial phone calls, you're like, boy, I don't know, maybe I shouldn't take this engagement, or even down the line, something's not going the way you want it to? Are there any sorts of red flags?
Yeah, one we've already mentioned is the short timeline where somebody comes to me and they say, hey, we really, really want to engage you. We need this report in 2 weeks. And, and I'm like, I can't, 2 weeks is not a reasonable timeline for me to review this information. Another one is when there are shorter timelines, especially if a firm is not willing to pay a retainer, that creates some question for me. We're to the point now, having done this for 7 years with some of the biggest firms on the planet. I mean, truly. And even smaller firms, that we request a retainer from every new client. It's just a corporate policy that we have.
Sure.
And I think that really kicks the relationship off in the right direction. We don't have to focus on immediate billing concerns. We can hit the ground running. And it's a good faith thing. I mean, law firms, they get retainers. And so why shouldn't we? So we have turned down cases simply because the law firm, and sometimes they're big law firms, say, well, we just don't pay retainers. And that's, I guess if I was early on in business and I, didn't have firms that I was working with and things of that nature, maybe I would say, hey, I need to build a reputation here and then I can request retainers. But we're to the point now, we've done this long enough that we request them. If somebody says no, maybe it's just not a good fit.
Outside of retainers, what are your other billing practices? For instance, do you do a project rate? Do you do hourly billing? And does your hourly billing change depending on the thing that you're doing or traveling, for instance? Tell me a little bit about your billing mechanism.
Yeah, so our rates are consistent. I mean, they change over time, as with any firm, company, whatever, depending on, cost of living and things of that nature. But the rates don't change from case to case or depending on how complex it is or anything like that. We don't really want to inject any bias into that. We try to treat everybody fairly. The rate is just what our time is. And we bill hourly with typically a retainer. That retainer is billed against, so we don't, expect a retainer and then bill on top of it. It's just sort of to help with the initial project kickoff. But we do have a different rate that's a little bit higher for our courtroom testimony and deposition time, just because that's the high stakes round. There's a lot of pressure there. There's a lot of preparation and time and expectation that goes into that, and so we have to really be on our game in those situations. So those hours are more complex and difficult than even just the normal research and report writing hours where we're in the comfort of our offices or, at home working on these things. So it's definitely a different situation where you don't have cameras and people, recording and documenting everything you're doing. So I think that's pretty standard. We don't have anything that's too unique there. But like I said, I think that has worked well for us and we've never had any issues. We bill at the end of the month. Usually through an expert search firm like Roundtable Group, and they're pretty good about making sure that their experts get paid timely, and so I appreciate that certainly.
Speaking of roundtable group, have you had luck? Do you find expert witness referral services to be useful in your practice?
Yes, very, very much so. They certainly have relationships with law firms, and they have brought me the majority of my expert work has come from expert search firms. And so I think, that it's funny because every one of those does things a little bit different too, and how they process it and what that looks like, how it unfolds, and when the introductions are made to counsel and how many people they refer. And so I would say that no two are exactly the same, but they don't operate so different from one another that it's not somewhat predictable in terms of process. But they have relationships in the network, and they do a great job of facilitating communication and making sure everybody's happy in the process. And I think they're a really important component of that relationship.
Earlier, you had mentioned doing things in the comfort of your own home, which brings me to a question about telepresence in Zoom. Have you done a fair amount of talking over the proverbial phone to your attorney, and perhaps even being involved in actions that take place virtually, like virtual depositions? Now I've seen there's even full virtual trials on occasion. Have you experienced both? And if so, what are some of the differences for an expert witness in appearing through telepresence and being there in person?
Yeah, so it's certainly much more convenient. I will say that. I have done virtual depositions. I've done virtual mock trials, certainly communicate regularly with the law firms we work with over Zoom or Teams or whatever the case may be. Occasionally phone if it's something quick and easy that I have a question about, or I need a document or something, I can't find something. So that's not really abnormal, but early on when I started, everything, even though we were pretty digital, I think this is the post-COVID era where everything is kind of going digital. I went to the courtroom. I went to the law firm, for deposition. So it definitely was a big change. It's certainly more convenient, but there are some things that change. Like, for example, the prep that takes place in your office or wherever you're recording your deposition, to make sure you don't have, distracting photographs on the wall or things of that nature. It's not cluttery because you want to have a professional appearance for the court and for the jury. And so there are some things that are a little bit different that you didn't have to do in the past. You just normally walked into the law firm and you went into their conference room or some mutual meeting place, and that's how you did your deposition. So it definitely has changed, but I think some of it's for the better.
How about demeanor? Do you find that it's difficult to maintain eye contact when, obviously on something like Zoom, eye contact is the camera, and, knowing where to look and how to present yourself, or do you find it pretty intuitive?
That's a good question. Yeah, it can be a little challenging because I think our inclination is to look at the person on the screen, which sort of has your eyes looking down.
Right.
So, and I'm guilty of that regularly. So what I what I try to do is, especially when I'm making a some sort of critical communication or something I really want to hit home with the jury or the judge, is I make a conscious effort to look directly into the camera when I'm talking about something that let's say the rubber hits the road here. This is something that's a really critical thing that I want you to take away from this message. I make it a point to look into the camera at that moment in time, and the rest of the time I don't spend um, too much energy focusing on am I staring directly at the camera, because in reality, the answers are really important. So I want to make sure that first and foremost I'm being accurate in how I'm answering.
Absolutely. Let's talk about some of your tentpole cases, if you can. Obviously, you can leave out any details that you are not able or obliged to talk about. But are there a couple cases that either change something about the way that you go about expert witnessing or reinforce something that you were already doing? Tell me a little bit about your tentpole cases.
Fantastic question. Yeah, in a case I had early on, I was sitting in the deposition, and the plaintiff's attorney asked a question that was way out in left field. And in that moment, my heart sort of sunk. I didn't have the perfect answer at the ready. And up until that time, I felt like I was hitting every ball out of the ballpark. And so I just paused for a moment and applied some critical thinking to what the best way to answer this is. And I just came to the conclusion that honesty was the best approach to this. I mean, I figured, the reality was I didn't know the answer in the moment. So I just said, hey, I don't know this without reviewing the data, but here is what I do know. And what I learned from that was the credibility doesn't come from having every answer. It comes from honesty and integrity under pressure. And I think that was really a defining moment for me because it's something I carried into future depositions. And I realized that, a jury member isn't necessarily looking for you to know every single answer because, first of all, if that's the case, that's wild in terms of being something that would be normal or typical because you just don't know what to expect. And nobody knows everything. I mean, that's impossible to achieve. So, I think at the end of the day, they really appreciate the integrity and the honesty and the ability to say, hey, I don't know that, or I need to review that, but here's what I do know.
Sometimes expert witnesses get engaged and they end up being part of a larger trial team. There might be other expert witnesses, there might be paralegals, there might be assistants, there might even be other attorneys that you're working with. Where does the expert witness fit into this cast of characters, and to what extent do you interact with the others?
Yeah, so I'm working with a firm on a case right now that they have a very large number of people that are involved. The firm is very big, and they have partner firms or sister firms that are involved, as well as, paralegals and all these other folks that are helping. And it seems that one firm sort of carries the conversation for, my particular component, and I communicate to their handful of attorneys, but there might be 25, 30 plus attorneys from all over the country sitting in on the meeting. And so most of the time I feel like I'm doing the majority of the talking on those calls, which I guess that's what I'm there to do as the expert. But there are some moments of awkward silence occasionally. It's challenging to figure out, who you're supposed to communicate with. But I think that the best way to view it is, I always call it the KISS method: keep it simple, stupid. And I just communicate with the people that are communicating directly with me. And I'm very careful about, if a paralegal sends me something or sending me documentation, I don't ever send a communication to a paralegal requesting anything. It's always directly to my point of contact attorney for just confidentiality purposes, just to make sure that, that information is maintained in a very confidential way, and I'm not communicating something to a person I shouldn't be. So just keep it simple as an expert, and you'll be all right.
Have you been involved in actions in a variety of venues, for instance, state versus federal, criminal versus tort? And if so, how are some of these venues different for an expert witness to work in?
Yeah, so the interesting thing is, it's not necessarily that the venues are extraordinarily different. It's more so that the timelines are very different on how the things are scheduled and in what order they take place. And that's honestly one of the biggest challenges, I think, as an expert, is to get communication from counsel on timelines. I think we spend so much time communicating to one another. It's almost like you end up becoming a part of the team, and we just assume everybody knows everything that's happening in terms of timeline. Like, hey, there's a settlement discussion this week, or, we expect a settlement in the next 2 weeks, or, this report is due in 2 weeks from now. We got an extension, and oh, we forgot to tell you that. So that can be a little bit of a challenge. And, if I could give another expert advice, it would be don't be afraid to ask timeline questions. Even if you just frame it as, for my scheduling purposes, has anything changed with the timeline, or is there any new information that you can share with me that might be helpful or beneficial as I work on this report or this research or whatever, so that, I don't waste your time and you don't waste mine. I think that's really appreciated. And there will always be things that they can't share with you that happen behind the scenes as an expert. You're sort of on a need to know basis, and you have to be okay with that. You're not you're not directly interfacing with the client and have the same responsibilities. So just work well with your team. And I think communication is an important part of that.
Do you have any other last advice before we wrap up for either expert witnesses or even attorneys who are working with experts?
I think that the best advice I could give, really, even both attorneys and experts, would be to listen. A lot of people, we all hear, the majority of us hear, and we can hear what information is being given to us. But what's made me successful as an expert is my ability to listen, because I carefully process the information. And that can really be the difference in making or breaking a case, especially in deposition, where a good attorney can frame a question to get the desired outcome that he or she is looking for, the desired answer. If you just listen very carefully, you will save yourself, you will save the law firm and their client a lot of difficulty and challenge simply by listening. And so I think it's good advice for attorneys as well. If they listen carefully to their experts and the experts listen carefully to them, everybody learns and becomes better simply by listening.
Absolutely sage advice. Mr. Mink, thank you so much for joining me here today.
Thank you, Noah. I appreciate it.
And thank you, as always, to our listeners for joining us for another edition of Engaging Experts. Cheers.
Thank you for listening to our podcast, Engaging Experts. Our show notes are available on our website, roundtablegroup.com.